I'll be talking about the three main traps we avoid in estate planning, and that's probate, taxes, and long-term care costs. But as we're thinking about an estate plan, we can think about it in phases. So in retirement years, you might have started to take Social Security. We're thinking about cash flow. You can start taking Social Security at 62, maybe full Social Security at 66 or 67, depending on your birth year. If you wait until 70, you can get a bigger payout. So we're thinking about things like that. Our retirement, pulling from our retirement accounts, our qualified accounts, and then as we get a little older, in our golden years, we're thinking about asset protection. And Joe will be going more into this in the second half of the presentation. But for asset protection, we're thinking about preserving our legacy, preserving our assets in the event that we might need to pay for long-term care. And again, long-term care, later in life, you're maybe not able to do those activities of daily living, and you need help, whether that's in an assisted living facility where you need some help, or maybe you need full-time nursing home care in a nursing home. So, as I said, the three traps to avoid are probate, taxes, and the cost of long-term care. What's probate? Probate's a court-supervised legal process of validating a will, paying a decedent's final expenses, and distributing assets to beneficiaries. Not having a will is a similar process. We call that dying intestate, and we look to the state's laws for the default beneficiaries. Trusts are the preferred mechanism for avoiding probate. We avoid probate in three ways: with trusts, joint ownership, or beneficiary designations. So a joint owner, you might own your home with your spouse. When the first spouse passes away, the second spouse is the owner by operation of law. There'd be no probate at that point. But if you did no other planning, on the death of the second spouse, that house would be a probate asset. If it was in a trust, there'd be no probate involved with that asset. And then beneficiary designations, you'll often see that with your qualified accounts. With your retirement assets, you'll name your beneficiaries. Maybe it's a spouse or a child. Taxes. You've already paid your income taxes your whole life, and we want to avoid paying taxes upon your death. Estate taxes right now aren't a huge concern. The 2025 estate tax exemption is about $14 million. That means someone can pass away with up to $14 million in assets and incur no federal estate tax. With spouses, that's $28 million. In 2026, the number is going to be $15 million. So that's up to $30 million we can pass on to our heirs, free of federal estate tax. New Hampshire is also a little tax haven. We have no state level estate tax. So we don't really have to worry about planning for most people to avoid estate taxes, but we can do other types of planning. We can do what's called basis planning. What's basis? Basis is the amount of money that basically you paid for a capital asset. For example, if you paid $300,000 for your home, that's your tax basis, $300,000. If you then sell it for $500,000, you've got $200,000 in gain. When you pass away holding an asset like that, you get a step up in basis to the fair market value as of your date of death. So if I passed away and my home's worth $500,000, my children would inherit it, and their tax basis is then $500,000. If they went to sell it, they'd have no capital gains taxes to pay. So we can think about basis planning, where we're going to try to preserve assets so that when we pass away with them, our children can get a basis step up. There's also reverse basis planning we can do, where our children might transfer assets to us, the older individual, and take advantage of our basis step up when we die. Because the federal tax exemption is so high, we don't really have to worry about gifting. If I gifted my house to my parents, I'm not going to incur any federal estate tax because the estate tax exemption is so high. So if I gift it to my parents and then they pass away, then I'll re-inherit that house with that step up in basis. Cost of long-term care. So we say about 69% of adults will need in-home assisted living or nursing home care, and those costs can be very high. Average about $12,000. If you need memory care, if you have some kind of cognitive incapacity, that can be even higher than that. We've seen up to $17,000. And with some proper planning, you can protect your assets from costs associated with long-term care so that you can qualify for Medicaid. And Medicaid has what's called a 5-year look back. So when you apply for Medicaid, the state's going to do a full 5-year audit of your financial life and see how many, they'll look at assets that you've transferred. And if you've gifted away assets to try to qualify for Medicaid, Joe will talk more about Medicaid numbers when we get to that portion of the program, but you need to be under a certain asset threshold, and the state will see if you've just given those assets away to your children for less than fair market value, and they'll penalize you and you won't qualify. So planning for incapacity during life, our 4 main documents really are your power of attorney and your healthcare proxy. Your power of attorney is someone that you name to basically help you with your financial life. It's almost like they're walking to a bank in your shoes, but it's a lot more than that. They can file taxes for you, pay bills, maybe you travel internationally and something happens and you need them to be able to access your funds. It could be maintaining your house, signing contracts, signing a long-term care contract. Maybe at this point you've lost capacity and you can't enter contracts on your own behalf, but you need to go into an assisted living facility. If you've got a financial power of attorney, they can sign that contract for you. If you didn't, they may need to seek judicial intervention to get what's called a guardianship to be able to enter contracts on your behalf. The healthcare power of attorney, in New Hampshire we call it the advance directive. It's a healthcare proxy and a living will in one document. And oftentimes people come into the office and they say, well, I already have a DNR, well, the do not resuscitate. That's different. A DNR is a specific medical directive that you don't want CPR if you stop breathing or your heart stops. Healthcare proxy is a broader legal document that makes your wishes known, who you want to be able to make healthcare decisions for you if you are not able. And the living will makes your wishes known if you're in an incurable, life-limiting condition. You can kind of think about it if you were in a persistent vegetative state. Do you want to be kept alive as long as possible? Do you want to have all methods used to maintain your heartbeat for as long as possible, or do you want to be able to pass away, basically? And then the HIPAA release is the release of your protected healthcare information to your agents so that they can make the best decisions possible for your healthcare so they're fully informed. Wills versus trusts, and we're still in the talking about incapacity part of the program because trusts, whether revocable or irrevocable, can help you with incapacity planning, whereas a will really cannot. A will only goes into effect after you pass away. In your will, you can name who your beneficiaries are, and you're naming who is going to serve as executive of your estate, and that's really it. Whereas with a trust, if you place assets into a trust, the trustee is now the manager of those assets. You can think of a trust, whether it's revocable or irrevocable, as a little company, and the trustee is the manager. The owners, the donors, or the grantors, add property to the trust, and then the trustees manage it pursuant to the terms of that trust. So it's great for incapacity planning because let's say you've got some bank accounts in there or your home, and you've got your child as a co-trustee. Your child does not need the power of attorney to be able to act with respect to those assets. They're in the trust, they're the trustee, they can manage all those assets that are in the trust. So
We've got some competition.
Yeah.
The good news is they're fixing the sprinkler system.
Oh, good.
But when did we can ask them October?
There's
Can you hear me over that?
there's a sprinkler system work going on.
Okay.
Yeah.
You don't think they'll stop?
I don't think so. Let's see how long it goes.
All right. Another great thing with trusts is, so as we talked about in the beginning, they avoid probate court and fees. If you just have a will, everything in your estate that's not in a will, that doesn't have a beneficiary designation, is a probate asset. If it's in a trust, it's not a probate asset, so your administration is more seamless. You don't have to wait for someone to get appointed of your estate. That's, if we think about the example of a home, if your children inherit a home and it's a probate asset, you're going to have to keep continuing to pay property taxes, maintenance for the home, plowing, mowing the lawn, utilities, and if they want to sell the home, they're going to have to wait till they get appointed as personal representative of the estate, and that can take several months. Whereas if it's in a trust, they can get that home on the market right away. They can sign a listing agreement and they can sign purchase and sale. So the speed is a lot quicker, and there's no court oversight. Again, as I said, probate is the court supervised legal process for getting control of those assets, and with a trust, it's a completely private process. Incapacity we covered, and you can change beneficiaries of trusts. Of a will, you can update and change. Revocable trusts, you can update, amend, and change as many times as you like as many times as you like. Irrevocable trusts, we do have a little note there. There's a caveat. You'd be limited to a class of individuals that you'd be able to change with respect to beneficiaries. And very quickly, what's the difference between a revocable and an irrevocable trust? An irrevocable is irrevocable. In very limited circumstances, it could be terminated, but what you do as a grantor is you give assets to this trust, and you say that you cannot change it. You're typically not the grantor of it, and you give up enough incidences of ownership that you can use something like an irrevocable trust to safeguard assets from Medicaid. You've given up incidences of ownership, and Medicaid will say that, oh, they don't actually own that asset, and they won't be countable for qualifying for those asset thresholds for Medicaid. For saving for estate taxes, a will not help. You cannot do any estate tax planning with wills, and neither with revocable trusts. With an irrevocable trust, you can, depending on the type of trust. Like I was talking about before, you're giving up incidences of ownership. So under certain circumstances, when you transfer assets to a trust, the IRS may consider that a completed gift. And so you've gifted those assets to the trust. You might use some of your lifetime gift tax exemption, but now it's outside of your estate, and it can grow and appreciate in value outside of your estate. A will does not protect your assets, provides no creditor protection before or after death. A revocable trust may, and irrevocable trusts can't provide creditor protection, especially with those Medicaid trusts.
Maybe to say something about thresholds in Maine and Massachusetts.
Estate taxes.
Yes.
Okay. For estate tax is something to consider. In New Hampshire, I mentioned there's no state level estate tax, but in Massachusetts there is. And it's only $2 million per spouse. Maine also has one, and it's $7 million per spouse. New York has one, and it's
7.16.
7.16. And if you have assets in those states, the state may try to assess an estate tax against you. And another thing too to consider with states like Massachusetts and Maine is those estate taxes are what we call, estate tax exemptions are what we call portable. So yes, a married couple has a $4 million state estate tax exemption in Massachusetts. But if you don't use the full $2 million on the death of the first spouse, you've lost it. Transfer assets to the surviving spouse, now you've got a large estate, you've only got a $2 million estate tax exemption, and now you're paying a large amount of estate taxes. You can use revocable trusts for tax planning for that purpose. We'd use 2 revocable trusts. We divide the assets between the 2 spouses, and on the death of the first spouse, you can put assets into what's called a credit shelter trust, where it would be includable in the death of the first spouse, and you use their estate tax exemption. It gets a little complicated, but it's if you have family in other states, or you have property in states that have that state level estate tax, it's worth planning around.
Could I just say, we have a lot of members from Maine, so if anything that is different between New Hampshire and Maine, I appreciate you pointing that out.
Yeah.
Massachusetts, I don't think so, but people certainly might have assets in Massachusetts.
Yeah, I know a lot of people have camps in Maine. That's a really common thing. And the $7 million is a little higher and more generous. I will say with those camps, what we often see is the titles are never transferred. It's just kind of understood that the next set of heirs are taking it over, and then it's a little bit of a mess where we have layers of probate. So I know that with these family properties, a lot of people have those camps up in Maine. It's great to have them in a trust. Another option is also an LLC, put them into a limited liability company, and we can make all kinds of arrangements for families to manage that property, and it stays in the family with less argument. The last topic is protects for special needs and disability. Often recipients of government benefits that have special needs, they'll also need to be under certain income and asset thresholds. Revocable trusts and wills cannot help them. If somebody inherits a bunch of assets that's on some kind of government benefit, they may lose that benefit until they spend all their inheritance. And you can use irrevocable trusts, they're called special needs trusts, to avoid that, and the assets will be managed on their behalf, and the terms of the trust will say the assets of the trust are to be used to supplement, not supplant, the needs of the beneficiary. That way they can get some extra money, maybe for a vacation, a trip to Disney, but it won't compromise their benefits. Just to summarize, who might need only a standard will, and that's somebody that has young children and not many assets. Revocable trusts, if you're not really concerned with Medicaid planning yet, revocable trust is good. If you're not really concerned with estate tax planning, saving for estate taxes, you're under that threshold for one person, under 15 million, then the revocable trust is okay. Irrevocable trust starts to come into effect if you are having long-term care concerns. Maybe you're in the retirement age golden years and you're thinking about maybe starting to shelter some assets for Medicaid applications. And again, if you're getting over that threshold, that federal estate tax threshold for one person, the 15 million in irrevocable trust starts to be a good consideration.
So this is perhaps one of the biggest concerns that clients come into our office with is there's a lot of fear about how am I going to pay for long-term care if I need it. As Bailey mentioned, roughly 2/3 of the people in this room are going to need some sort of care. Either that's in-home, at a nursing home, or an assisted living facility. And that can come in lots of different forms. Sometimes spouses care for each other or a family member moves in, and at other times the needs are so great that an institution is the only place that can properly care for a person. And no one likes to contemplate the thought of that. I have yet to have the client come into my office say, sell my house, I'm ready to move into the assisted living facility. Usually it's a difficult process and not one that people enter into voluntarily. It's something they have to do, not something they want to do. We're very fortunate to have lots of options in this area, and some of the nicer nursing homes, not too much different than the environment you'd have at home. But of course, just as with anything in life, you get what you pay for, and paying for the cost of nursing home care can be quite daunting. So we're going to talk about some of the different ways that you can pay for nursing home care. We call this solving the long-term care puzzle. I think we're ready for that. Good. So there's lots of different options. Perhaps the most popular option is something that's known as a continuing care retirement community. You're probably familiar with some of the ones around here, like Riverwoods, where you buy in. It's almost like doing a real estate transaction, and there are multiple levels of care: independent living, assisted living, and nursing home care. And these types of communities are very popular because you can have two spouses receiving different levels of care and living in the same facility, which is probably the method of choice for most people. Community-based care can be delivered either by a home health aide, someone, a professional that takes care of people for a living, and also be delivered by a family member. And there are programs under Medicaid that sometimes can reimburse family members for the time that they take off of work to care for family members. Assisted living facilities are sort of somewhere in between. Usually that there are some activities of daily living that are taken care of at the facility, but usually these people are capable of doing many tasks independently. And then a nursing home is usually when there's some sort of cognitive impairment. And that can come through a lot of different avenues. Stroke, various forms of dementia, Alzheimer's, Parkinson's. There's not just one way into the nursing home. There's often can be a combination of factors affecting people. The great news is that if you plan early enough, you're going to have a lot more options available to you than if you put this off and try not to think about it. The earlier that you start addressing, how am I going to pay for this if I need it, you can actually save yourself and your family quite a lot of money. We talk about having a support circle, and being part of a church community is one great sort of support circle. But we also think about other areas. Social is certainly one of the most important. Family, friends, neighbors. The financial side, obviously, that's a big component of everyday life. Paying for ongoing costs associated with living. The tax and legal aspect. Many people are afraid to consult with advisors, thinking that it's going to be an expensive process. But I can tell you from over 20 years of experience that the most expensive thing is not planning. It's very difficult to have people come into our office. They bring mom or dad in, and they're already in the early phases of dementia. And at that point, the planning options are much more limited. Whereas the people who come in when they're 65, 75, prior to the onset of these infirmities that at some point affect us all, those people can put plans in place so by the time they do need care, if they need care, the proper structures have already been in place for that 5-year look-back period. Housing is obviously a big part of most people's assets, particularly here. We've seen a lot of appreciation in real estate equity values over the last 20 years, and many people who purchased their homes for $100,000, $200,000 are now living in $1 million homes. It's, for most people, the largest asset they have. Obviously, healthcare is important, and one thing that we encourage people to do, again, being proactive, starting early, is getting their caregivers and children in touch with each other. It's always good when a relationship is established between a doctor, an attorney, an accountant, and a financial advisor, while mom and dad are young and healthy and able to pass the baton with a clear frame of mind, and to introduce whoever is in that support circle. Could be family members, could be friends that are maybe a generation younger, could be a neighbor, could be somebody in their church community. If that relationship is built before, if the relationship is built before the crisis happens, the work that needs to go into managing a transition period for that client is much, much smoother. I can't tell you the number of times we have children walk into our office saying, I need mom's power of attorney, she's in the hospital. And we don't know who this person is, and they come in demanding private client documents. Whereas if the relationship has been built ahead of time, hopefully that handoff has occurred prior to an emergency happening. Next slide. Yeah. So the biggest question is, how do we pay for it? And the good news is that there's lots of different avenues and options that people have opened to themselves, more than ever now, and we'll go through some of those. The first, and for many people, the preferred option is long-term care insurance. It used to be that long-term care insurance policies were both expensive and very inflexible. You had to pay an annual premium that could go up over time. And the problem with these traditional policies is that they were underwritten using actuarial data from the past. So many of these companies are now in a situation that's called runoff, where they're literally going out of business because the data that they used from the 1980s and 90s is no longer really applicable in the 2025 era, when people are living significantly longer, and things that would kill people 20 or 40 years ago now can be a simple outpatient procedure. Obviously, Social Security is something almost everyone has if you've paid into it. A pension, we see fewer of those nowadays, but many public employees still have them. And of course, retirement plan distributions. What we do in the long-term care planning process is see what would be the potential cost and adjust that for inflation over time, and then see what resources that people have to pay for that. We like to say that you can protect assets, so things like your home and savings and investments that are not in a retirement account, but you can't protect income. So many people don't realize that if one spouse has more Social Security and pension income than the other, and that spouse goes into a nursing home, all those assets are likely to be used up for those care costs. Investments and savings, these are things that are outside of a retirement plan. Equity in the home, for many people, it's their largest asset, particularly here on the seacoast. The amount of home equity is outstanding. Medicaid is a federal program that is run by the states and implemented at the county level. So you will see differences from state to state. I'm going to primarily talk about New Hampshire here, but be aware that if you're from Maine, similar rules, slightly different. Long-term care insurance. Traditional long-term care insurance, you paid in, and if you didn't use it, you lost all the money you paid into it. Because the underwriting was very difficult, nowadays what we're seeing, I would say 99% of the time, is people who purchase life insurance that has a long-term care rider attached to it. The rider might cost you a few $100s extra a year, but well worth having. The idea is you put a lump sum into an insurance policy. If you need the death benefit for long-term care costs, you can borrow against that death benefit and use that towards the cost of your care. If you don't need it, however, your heirs get a life insurance benefit. So unlike traditional long-term care, where if you didn't use it, you lost it, here you can have your cake and eat it too. Many of these policies, if you get them early enough, and this is something you want to be thinking about in your 60s, maybe early 70s, they're generally not issued after age 80, and even if you are able to get one in your late 70s, they can be very expensive. The idea is you put in a lump sum of money, and that buys you a certain amount of coverage. And you have to go, all these policies are underwritten, so you have to be eligible for life insurance. If you've had a recent bout of cancer, chances are you wouldn't be eligible for it. The other great thing about these policies is that if you need to access the cash value that you put in, you can often withdraw it without any major penalties. So, next slide. Social Security, as we said, most of us have it in some form. This can still go a long way. Many people have benefits in the thousands of dollars a month, and this can form an important part of the long-term care puzzle. And if we say it costs in this area around $12,000 a month, if you have a $3,000 a month Social Security benefit, that's going to get you about a quarter of the way there. Pensions are also, for the people that have them, can be wonderful. The only difficulty is you can't protect them. There is one little mechanism that can work, which is something called a qualified domestic relations order. Not done very often, but this can allow you to split the pension between the two spouses. so that the spouse who's healthier and living in the community can still have some of that benefit. And then survivorship benefits can still apply to pensions. If you have that option, most people have, when they take their pension, they can choose the survivorship option. It's always a good thing because that pension can continue on for the benefit of the surviving spouse and pay for their nursing home costs as well. Retirement plan distributions. Actually, we should update that. That should be now. They're men at age 73. This is things from 401ks, 403bs, IRAs. These are the types of retirement plans. Something that we do for clients is many times there's a question of where's the most efficient, tax efficient place to take payments, to derive the payments for nursing home costs. And many people don't know that you can, if you itemize deductions, you can deduct about 80% of nursing home care costs. And by just doing some simple planning, use retirement plan distributions that will be offset by those nursing home costs so that your kids are inheriting assets that get that step-up in basis rather than pre-tax assets like a retirement account. Even if someone spends a very short period of time in a nursing home, doing this sort of planning can save you tens, if not hundreds of thousands of dollars in the long term. Other opportunities potentially is converting the retirement plan to a Roth IRA, if that's going to help potentially with Medicaid eligibility down the road. Next slide, great. Investments. A good rule of thumb is if you have a fairly conservative portfolio, you might be able to get 5 or 6% a year of income off of those investments. And for many people, if they take some equity from their home and their retirement accounts, add on a little bit of Social Security, maybe a little bit of long-term care insurance or cash from other sources, they don't need to touch the principal. They can live off of the income that is generated by their assets. And more, especially if there's a second spouse that goes into a nursing home, the costs are able to be covered by converting home equity and retirement plans into more income-producing investments. Some of the ways to do that, investing in preferred stock, often they carry a 5 or 6% dividend. Tobacco companies pay a very nice dividend, as do utilities. That can be everything from your local water or electric company or gas company. REITs, real estate investment trusts, puts you in the position of a landlord, and having a diversified portfolio of real estate that's producing income. As long as the REIT distributes 90% of its income, it doesn't pay tax at the corporate level, and you can use that income and have the tax effects offset by those nursing home deductions. High yield bonds, these can be a little bit risky, but with proper investment advice, you can choose safer bonds that have a more significant yield. And telecom companies, companies like Verizon and AT&T pay really nice dividends. Some people may need to invade principal. They're not going to be able to just live off of the income, but even still, repositioning investments can delay the need to invade principal. You have to take a look at the total cash flow needs of the couple, not just the person in the nursing home. It's kind of amazing that if you have one person living in a nursing home, the costs aren't cut in half for the person that's staying in the marital home. Often the cost of heating and utilities and property taxes, insurance, maintenance, upkeep, all those things stay the same. So there's really not going to be a lot of savings that's realized when that first spouse either passes away or needs to go into a nursing home. Savings, a lot of people, we see people that have a lot of money put stuff in the bank, CDs and savings accounts earning relatively low yields. Just by repositioning those assets, you can often get that little bit of extra income that you need. And you also can use it to pay down debt. Many people don't realize this. Many people are very afraid of the nursing home taking the house. But in New Hampshire and every other state, as long as one of two spouses is living in that house, it's not a countable asset for Medicaid purposes. We also see people that have lots of accounts spread over different banks, different institutions. Many people are afraid of the banks failing. Hasn't happened for a long time. If you do want to keep stuff in multiple different banks, do that inside of a brokerage account. You can have multiple CDs and bank savings accounts within a brokerage account, so you only get one statement rather than 5 or 6. Cleaning up all of those savings accounts and organizing them for tax purposes can be a real burden. And if there's one thing that you can do that will make life easier for the next generation, it's streamlining those accounts. Maybe each spouse can have a retirement account and have a checking account, and maybe an after-tax investment account if there's investments outside of a retirement account. Most people don't need more than that. And if you have multiple bank accounts, multiple savings accounts at multiple institutions, I tell people for every account that you have, it's going to add a couple $1,000s to the cost of administration for legal and tax and accounting purposes. So in the handouts, you'll see there's a little flyer that talks about ways to make your estate easier to manage. That's certainly one of them that you can do yourself. You don't have to do it all at once, but perhaps you start consolidating those accounts. Home equity. Lots of different ways to tap into home equity, and for many people, this is their single largest asset. That can be through the sale of the house outright. Could be through something that's called a reverse mortgage. Reverse mortgages sort of got a bad rap about 20 years ago, and after the financial crisis, there's a lot more regulations that are put in place to make them safer and much more streamlined and consistent process across people that offer them. You can take the proceeds either from that reverse mortgage, if the rate is low, or from the sale of the home and invest it instead of the home becoming a liability where you have to pay for the maintenance, taxes, insurance, utilities. It can become an income producing asset. So for many people, if they take the equity in their home, sell the home, most people, married couples have a $500,000 capital gains tax exemption if they sell the property while they're alive. Taking that home equity and investing it can really put people over the hump where they're able to self-fund for nursing home costs. Line of credit is another option, particularly if there's desire for the one spouse to stay in the home and there's just a little bit of shortfall every month. A line of credit can be a way to access that home equity in smaller amounts. Doing a sale leaseback of the home, we see this particularly when people want to keep property within the family. They can actually sell it to their children and lease it back. This can create tax advantages for the children and get some of that equity out of the parents' estate. Also, it's people talk about a spend down of assets to qualify for Medicaid. This is a great time if you have deferred maintenance and you have a house that's in a trust and that is otherwise protected. Use some of that money that's outside that would be otherwise subject to payments for the nursing home to make repairs and improvements and allow either one spouse to age in place to stay in the house or to get it ready for a higher sale value later on. Medicaid planning, again, the key here is starting early. This is not something that is done just once and done. It's something that's kind of an ongoing process that we engage in with clients. Usually they come in about age 65 to 75 and are thinking about this. And if I would say if you have less than $2 million, this is probably a good thing to be considering. Medicaid planning trusts have different varieties. Most often what we see is the individuals, the husband and wife, will retain the right to income from the properties, meaning that if they were to rent out the property or if the property was sold and it is invested in a way that generates dividends and interest, they still have the right to that income. Sometimes you see no income trusts or income discretionary trusts, less frequently, but that's another possible structure if you want to shelter the maximum amount of assets. When you're setting up a trust, I would say 99% of the time, trusts are transparent to the grantors, the people setting up the trust for tax purposes. So the trust, while you're alive, doesn't need to file a separate tax return. Anytime that you retain an interest in a trust, whether that's the right to live in a house or the income from that trust, those assets are going to get a step up in basis as well. So you don't need to worry about putting a house in a trust that you're going to lose that tax advantage that Bill talked about. Important to think, if you have annuities in your plan, they can be a little tricky inside trusts, something you definitely want to talk to an accountant and attorney about. And perhaps the most important issue is that 5-year look back. Doing the planning early enough so that that 5-year look back period elapses before you need care. Again, when clients come in and they're at the threshold of going into the nursing home, it's often too late to do a lot of planning. All right, next. So Medicaid eligibility is based generally on two things, income and assets. We can protect assets, but we can't protect income. Different states treat retirement accounts differently, but income is generally things from Social Security, pension, annuities, and investment income, dividends, rents, interest, capital gains, annuity payments. Assets that you can protect are non-retirement accounts, whether that be cash or investments, and real estate other than residence. So you have a rental property or a camp somewhere. Those are good candidates to be put inside of a trust. Generally speaking, retirement accounts are not protected. And often the typical financial advice that you hear is let's keep those tax-deferred accounts open as long as possible. But you really want to do a deep dive and model everyone's individual situation. Sometimes that's actually the best place to be taking money out of if you have a loved one in a nursing home. Do the next one. This is a pretty typical scenario that we see in this area. People have a substantial amount of home equity. They have some investments outside of a retirement account, some investments inside a retirement account. Maybe there's a pension, maybe this could be a couple of school teachers or government employees, and they get Social Security. Do the next slide. Actually, let's go back one. So in a case like this, the house and the non-qualified investments are really good candidates to consider putting into an irrevocable trust to protect them. The retirement accounts, pension, Social Security, those are, really can't protect them, particularly in New Hampshire. Some states like New York, they count the distributions, the required minimum distributions from the retirement account, not the retirement account itself. So a couple like this, they can probably shelter roughly 2/3 of their assets, but almost none of this extra income. Right now, the monthly income threshold in New Hampshire that can be protected is about $3,000. So anything over that amount is considered fair game, and living off of $3,000 a month can be difficult. So by sheltering investments and home equity, you can use those investments inside the trust to take care of some of those expenses associated with the house. It's another good strategy. We'll go on. These are more specialized scenarios that don't affect everyone. Sometimes there's a privately held business in the family where the retired generation still has an equity interest in the business. You want to be very conscious of that if that applies to you. Investment properties and vacation homes. A lot of people in retirement live off of some rental income, or they have that camp somewhere. Got to be thinking about that. Those are also good candidates for protection. Residency and domicile issues. We see this a lot with people in a couple different scenarios. One is if they have more than one residence, what state is the place that they can apply for Medicaid? And is there an advantage to doing one over the other? And the costs of care in the Northeast tend to be very high. If you have a place in a warm, sunnier climate like South Carolina or Florida, often the costs of nursing home care there are much lower, and that can be a factor for people too. Sometimes people have decided to do charitable giving, and charitable giving can be a way to protect assets. The great thing is that if you give stuff away to charity while you're alive, it gets an income tax deduction and an estate tax deduction. So you have double whammy there. Next slide. Okay. Jurisdiction shopping. This means going to a different state and applying for Medicaid there. Florida and New York are two states that have a concept of spousal refusal. So you can transfer all the assets to one spouse, making the other spouse poor, and the spouse that has all of the assets doesn't need the care, can refuse to pay for the other spouse and get them Medicaid. Yes. Much more efficient than getting divorced, which is something else people consider doing. But if you already have a family member there in New York, you only need to be a resident for 1 day to qualify as a candidate for Medicaid. It's a little bit out of the box idea, but in some situations where there's not adequate resources or there's a big age gap between spouses, and women already live longer than men by about 5 to 8 years, depending on which studies you read. And if there's a significant age gap, that surviving spouse, the community spouse, often a woman, might be living for another 15, 20 years and need the resources that have been saved and not want to tap into their life savings. In New Hampshire, the maximum amount you can protect as a spouse is the equity in the home, and the current threshold is $157,000, which is not a lot to live off of. So if you have family members in other states, it's often worth checking out what their rules are. These rules also change all the time. As the population ages in general, there's not enough money that's been put aside to fund these programs at the federal or the state level, so states are becoming more and more restricted on who can qualify. Non-divorce quadro, it's a qualified domestic relations order. I've only done this once, and you go to the family court and say, please separate our assets, and this way we can potentially save some of that pension income for one of the spouses. Next slide. Bailey talked a little bit about transferring assets on death. Won't go into this, but generally speaking, if you can avoid probate, you want to do that. And that can be done through a combination of trusts, beneficiary designations, and joint ownership. Go to the next slide. This is in the handout that you have, and these are some really good things that you can do. They're fairly simple. All but the last one really don't require a lawyer. And the more preparation and organization you can do in advance, having these conversations, even though they're difficult conversations, with loved ones, with your trusted advisors, can make the process so much easier. It's already going to be difficult for people losing a parent or losing a spouse, getting things organized and tidied up while you still have all of your faculties is perhaps the biggest, the best return on investment. We talked about a lot of these things. Something I see fairly frequently is people who name co-trustees or co-executors, or sometimes we even see 3 children named as co-executors. Don't do that. It's a very bad idea, particularly if kids don't get along. It's not going to be easier after you're gone. It gets worse. And often, if you have 2 or 3 co-executors, you have a chorus of people, their spouses, their children, chiming in about what they heard and things they learned on the golf course, or from a friend who lives in a totally different state that don't apply in the state that you live in. If you have any assets, if you get a small dividend check from Prudential, MetLife, or Computer Share, one of these companies, you want to get those assets into a trust or regular brokerage account. They're very difficult to deal with. A lot of people have these from uh, investments that they made directly into stocks when they were employees, Verizon, IBM, AT&T, or from insurance companies that demutualized. They turned from a mutual company into a stock company. So you have any of those assets, pay particularly close attention. They're very difficult to deal with. Better to handle those when you're alive. Keep with warm hands. You know, there's nothing more difficult for me than, as an attorney, than dealing with a whole laundry list of specific requests from, you know, the Hummel collection to Grandma's China to the, give all that stuff away while you're alive if you can. It's gonna, if you put that in your will or in your trust, you're gonna need to get an appraisal for it, and you're gonna need an attorney to draft a receipt for it. Often the cost of those appraisals and receipts and tax accounting to the court or to the beneficiaries themselves exceed the value of the stuff that's being given away. So give it warm hands. One of the best things you can also do in your spare time is organizing photos and family history and making copies, and they can often now be done digitally, which is doesn't take up space on the shelf, doesn't gather dust. Great thing to leave for people is a well-organized family album. And finally, setting up a trust. It's not a do-it-yourself thing to do. There's a lot of great forms online, and I tell clients that the reason we get paid so much is not because we come up with new forms, it's because we know the right ones to use. And I've seen many cases in which people try to save money by doing it themselves, but end up incurring more legal fees to fix a mistake that they didn't even know they were making. All right, good. In your packet, you're going to have these 2 sides of 1 page that are these action item checklists. Good way to start getting organized. Again, one of the best gifts you can give to that next generation who are going to be managing their estate is to be organized. Get all of these things in one place. I tell people you don't have to do this all at once. It can seem overwhelming. I say pick one thing a week and get that in a binder. Let that binder sit someplace that's safe, but where the next person knows where it is. Maybe it's in a closet or in a safe. Don't put it in a safe deposit box at a bank, though. If you die and there's stuff inside there, there's a complicated procedure to get access to that. Having all things like your last tax returns, birth certificates, marriage certificates, this can all be very useful if there is a need for a Medicaid application, and getting it organized ahead of time. It is so much easier than having to go find these things. The action item checklist gives a lot of legal, financial, and practical advice about getting things organized and how to start having conversations with the people who are on your support team to tell them where things are if there's an emergency, and getting those support structures in place well before you think you need them.